A retired Supreme Court judge says courts do not proceed by determining whether or not the principles make sense or are right or wrong. They apply the law as it is. Justice S.A. Brobe was speaking at the 2014 inaugural lecture of the Ghana Academy of Arts and Sciences.
The term contempt of court, although not uncommon in the judiciary, became very popular during Ghana's election petition case in August 2013. Some political figures and media practitioners were cited for contempt for scandalizing the courts and lowering its authority and credibility in the eyes of the general public.
My lords, I offer an unconditional apology and withdraw the comment and the choice of words that were used, which might have embarrassed the court or embarrassed your lordships.
My lords, I apologize for my irresponsible statements. I should have been a little bit careful and picked and chosen my words very carefully.
Before the court begins to sit, people sit on radio. And in fact, when the cameras are thrown into this hall, people begin to comment on all manner of things.
Sign a bond to be of good behavior for 6 months or in default 6 months imprisonment. He should also retract and apologize for his contemptuous utterances over the same Oman FM, the platform on which he indulged in them, within 24 hours.
This raised a lot of concerns from ordinary Ghanaians and even those within the judiciary about the extent of power of the Supreme Court and whether its action was fair. At a public lecture organized by the Ghana Academy of Arts and Sciences, a retired Supreme Court judge, Justice S.A. Brobe, made it clear that courts do not proceed by determining whether or not the principles make sense or are right or wrong. They apply the law as it is and not as it ought to be.
And the fact that the whole country was on the edge waiting for the outcome of the case, and several other factors which I cannot discuss. The court gave a ruling which set the president on the procedure for scandalizing the court. That's simple as that. That is the law now. And until the law is changed, all judges and magistrates and all of us, in fact, are duty bound to apply the law as it is. Not the law as people may think that it ought to be. The law as it is, not the law as it ought to be.
He explained, although the law is supreme, there have been occasions when judges have taken it upon themselves to criticize decisions given in courts with a view to initiate change in the law. Some attendees at the public lecture shared their views about.
Until this point, we always thought it that because of the principle that you cannot be a judge in your own court, you cannot sit over a matter in which you have been scandalized. But it has brought the point to the fore and explained it clearly why the Supreme Court took a particular position in the celebrated case of the election petition. Because most people or most lawyers took the view that it was wrong for the Supreme Court to have sat on the matter when the criticism or the scandal was about the Supreme Court. But this explanation, I believe, brings to an end the debate that it was natural justice against a constitutional principle. And in such a situation of conflict, the constitutional provision has to prevail.
He talked about contempt, civil contempt, criminal contempt and all that. And he's really given us an insight as to what contempt is. I'm really happy because I'm really going to use this. Because most of them, there are some of the things that I did not really know about. I knew about contempt as a whole, but I didn't know that there were other laws that talk specifically about contempt. I'm really glad that I know now, and I'm really going to use it wisely.
The inaugural lecture was under the theme, The Law and Practice of Contempt of Court in Ghana.
So Justice S.A. Brobe, a retired Supreme Court judge, the lead discussants in that very forum that took place at the British Council here in Acquah. Well, that will end news highlights for the moment.